This is Right to Life Radio with John Gerardi on Power Talk 96.7 and AM 1400, a production of the Right to Life of Central California. And now, here's your host, John Gerardi.
Talk about the
Check 1 2. I'm good, but your mic is never.
The old not plugged in. That's all righty.
This is Right to Life Radio with John Gerardi on Power Talk 96.7 and AM 1400, a production of the Right to Life of Central California. And now, here's your host, John Gerardi.
Last Monday, the Supreme Court announced that they would take on what is sure to be the most important abortion case in at least 30 years and possibly ever since Roe, Dobbs v. Jackson Women's Health Organization. We were able to talk about it just a little bit last week. We had Sissy DeLana Wood on to talk about several awesome new pro-life initiatives starting in Fresno, the Obrea Medical Clinics of Central California, the beautiful cemetery for the unborn that's been established in Bakersfield. But we didn't have our guy, Jonathan Keller, on. So Jonathan Keller from California Family Council is here. Jonathan, you and I are going to talk about Dobbs. And we're going to talk about how this is important and what could happen with this, the case that could... If anything can, this is the case that could lead to the overturning of Roe v. Wade.
I am excited, especially because astute listeners, observant listeners, will know that we have been kind of talking around this case for several months because it has been I think it's every week at least, isn't it, when the Supreme Court has a conference? If not every week, it's at least every month.
I don't know exactly how often it is, but yeah, it was basically the Supreme Court took something like 4 months or maybe more than that. I don't know. It took them an extraordinarily long time
for people who don't like. If you
to
don't
decide to take the case,
if you don't follow the court regularly, there's a
which 99.9% of the world does not,
which is fine. I mean, you don't have to be a nerd like us, even if it is fun. But I will say you should go if you're on Twitter and you do like to follow the news. You should go and follow the Twitter account for SCOTUS blog. And just to clarify, this is not the official Twitter account of the Supreme Court.
Right. SCOTUS blog gets a lot of hate mail when the Supreme Court issues a controversial decision, and SCOTUS blog. And by the way, for those who don't know, that's an acronym. It stands for Supreme Court of the United States. I don't know why people started using it.
SCOTUS. I know.
I studiously refuse to use it
when
I write about it on Twitter.
Hashtag SCOTUS.
Anyway, so there's a website called SCOTUS blog, and it is a blog, not affiliated at all with the Supreme Court. The writing is done by a bunch of different lawyers who are involved in it, and it covers issues.
It's a news organization.
Yeah, and it covers issues that go on at the Supreme Court, and very well, I'd add. Yeah. I think they get a very nice, broad, representative spectrum of opinion and highlight op-eds by a lot of different people.
I was going to say, they solicit explicitly op-eds from, obviously, liberal journalists, liberal writers, liberal attorneys, but they also do from conservatives. I mean, they've had some...
They get. I thought the joke we were leading to is they get op-eds from various liberal Democrats and also liberal Republicans.
That's right.
Yeah. Anyway, so, no, just kidding. Anyway, it's a very good site. And anytime the Supreme Court issues a bad decision, people confuse SCOTUS blog with the Supreme Court itself and flame them with angry tweets and things like that.
So if you go, it's at SCOTUS blog, BLOG on Twitter. If you go there and check it out, independent news and analysis on the U.S. Supreme Court since 2002. They have lots of great information that they do. And a lot of it is serious on politics and policy, but some of it is also fun and silly. Talking about, for example, just John, this is a little afield, but it's just fun to give you some fact that the justices are people too. I think as it is, every time a new justice comes on the court, they are put in charge. The newest, most junior justice is put in charge of the cafeteria.
The Supreme Court cafeteria. Yeah, which apparently this was a role that Brett Kavanaugh really engaged with very intensely. Yeah, that's what I heard.
Well, it's
so now ACB is in charge.
Well, it's so funny because you think about it, and you have the newest justice, Justice Alito, was confirmed, I think, in 2005. So Justice Alito was confirmed in 2005. He had that role for 4 years until Justice Sotomayor was in office. Then Justice Kagan was confirmed, I think it was in 2010?
It was right after.
Or 2010?
Yeah.
So Justice Kagan was confirmed, and then she had that role for basically 8 years.
Right, yeah.
Until Justice Gorsuch was confirmed.
Right.
But under the Trump administration, you had Justice Gorsuch, Justice Kavanaugh, and Justice Barrett. So now Justice Barrett
in charge. All right.
She is. So the funny thing is, if you were on the East Coast, John, you've probably heard about the cicada situation.
Yes, I have.
Are millions, if not billions, of cicadas. So apparently there is a new thing that people are eating cicadas. They're cooking them.
I've heard of this.
So SCOTUS blog says, paging Justice Barrett, we found a new menu for the Supreme Court cafeteria, locally sourced.
All right.
Scrumptious cicadas of the United States.
That's disgusting and revolting.
Right.
And I'm sure Amy Coney Barrett, as a noble daughter of, I guess actually she's originally from New Orleans, but anyway, a noble daughter of the Midwest, I'll claim her for the Midwest as a Notre Dame grad, would never bring cicadas to the Supreme Court cafeteria. Anyway,
so all that to say.
Anyway,
if you've been following SCOTUS blog or our show,
after that enormous digression, needless to say,
this has been something that they keep reporting on, the fact that it's very conspicuous that the Supreme Court has not issued a decision on this case, or made a decision. I should say.
So let's get down to the nitty gritty of what the actual case is about.
Yes.
Okay.
Dobbs
v. Jackson Women's Health Organization. So this is a case that originated in Mississippi, and the state of Mississippi had passed a law banning essentially all abortions from 15 weeks of pregnancy onward. Okay, basically, I think it was specifically a law banning dilation extraction abortions, and so it effectively eliminates most second trimester and onward abortions. The critical thing is that 15 weeks is far before the point of fetal viability. Okay, fetal viability is, depending on your hospital that you deliver in, fetal viability and certain health conditions with the baby, fetal viability is somewhere around 22, 23 weeks. And it's not really like a clear defining line. It's more of a spectrum. There are some hospitals where if you have a 22-week baby, the survival rates are 10%, and there are some hospitals where the survival rate is 60%. So it depends on how your NICU unit is set up, the priorities within your NICU unit, how good your NICU unit is. I think your outcomes are better if you have your baby and he goes to the Valley Children's Hospital NICU here in Fresno, as opposed to Podunk Hospital, help, in the middle of nowhere, Alabama or something. Okay. At any rate,
no offense to our Alabama listeners.
No offense to Podunk, Alabama, but the state of Mississippi bans abortions from 15 weeks onward. This is before the point of fetal viability. And existing Supreme Court decisions, most notably Planned Parenthood versus Casey, which has been the controlling Supreme Court precedent on this question since 1992 when it was decided. Planned Parenthood versus Casey basically said, before fetal viability, state governments and the federal government cannot ban abortion, nor can they put any undue burden in place to limit the ability to get abortion. Now, what's an undue burden? Very good question. That's a question that Justice Scalia, enraged, asked in 1992. He was furious because it was sort of a whole completely new standard that Justice Kennedy sort of pulled out of his ear. Hopefully he pulled it out of his ear. So this, and effectively what it turned into was any restriction on abortion was undue if Justice Kennedy or Justice O'Connor thought it was undue. So that was sort of the silliness of it. And effectively, what that standard did was it turned our Supreme Court into the nation's highest abortion regulatory board. That's really what the Supreme Court is. Anytime a state tries to pass some kind of novel abortion restriction, it immediately gets appealed up to the Supreme Court, and the Supreme Court has to decide whether or not this restriction on this kind of particular healthcare procedure, I say in scare quotes, whether it's due or not. You'll notice that the Supreme Court does not involve itself in state government restrictions on, dialysis care, on heart procedures, on certain kinds of drugs, on this, that, or the other, on FDA decisions or approvals about drugs. In spite of the lie that's perpetuated constantly, abortion is just healthcare, abortion is just healthcare, abortion is essential healthcare. There's no other form of healthcare that receives this intense level of Supreme Court strict scrutiny. So the existing law in the books is that before fetal viability, abortion is basically untouchable. And what Mississippi did was ban abortions before fetal viability. Ban abortions from 15 weeks onward. Again, fetal viability is somewhere around 22 weeks. Clearly, there's a segment of the population for whom abortion would be illegal before viability in Mississippi. This law was argued. The lower circuit courts, in spite of the fact that I think this was a very conservative circuit, I think it was the Fifth Circuit, which is very conservative. The Fifth Circuit Court of Appeals had to rule that this law was unconstitutional in spite of the fact that it's super conservative, because circuit courts have to apply existing Supreme Court precedent. That's sort of the rules of how they're sort of supposed to function.
If you've watched any hearings for non-Supreme Court justice judicial confirmations,
right?
Repeatedly, you have the conservative senators saying, what are you going to do about Roe v. Wade or about gun rights or whatever? And you have the liberal senators, conservative senators saying, what are you going to do about this or that? And it's almost like Invasion of the Body Snatchers. You can watch, because it's like, I will faithfully apply a precedent as written.
I will faithfully apply a precedent as written. Judicial hearings are just the biggest nonsense kabuki theater exercises. Anyway. So that's the case that's before the court. Now, the Supreme Court basically waited for a long time to decide, okay, should we take up this case? Now, one of the things that was complicated, I think, is that the existing Supreme Court precedent is very clear. So all the lower circuit courts were just applying that same precedent. There wasn't much disagreement among the lower courts as to how to apply that precedent. It's clear. The existing Supreme Court rule is no bans on abortion prior to fetal viability. So usually the Supreme Court only will take on a case if there is what's called a circuit split. So there's some point of law where the First Circuit is reading it one way and the Ninth Circuit is reading it another way. Or the Fifth Circuit is reading it one way and the Seventh Circuit is reading it another way. Where the various circuit courts, the federal appellate courts that are one click below the Supreme Court, if they are disagreeing with each other on some point of federal law, the Supreme Court will take a case in order to resolve the dispute. In the case of banning abortion before fetal viability, there's no dispute, but basically it's just a question for the Supreme Court of, well, do we just want to change our existing rule? And it appears that that is precisely what the court is considering. Now, to accept a case, you only need 4 of the 9 justices to say yes. Yes, we will accept the case.
But John,
and we don't know exactly who those 4 justices are.
But you need 5 justices to make a decision, and 4 is less than 5. So
that is correct.
So how can you know what's going to happen beforehand?
We don't. So, and that's one of the big questions. So, are there only 4 justices who are willing to change Planned Parenthood versus Casey? Are there 5 justices willing to change Planned Parenthood versus Casey? Are there 6 justices? Are there 4 who want to change it to a certain extent, and maybe 1 or 2 who only want to change it to a more limited extent? This is the big guessing game, because we have no idea. We don't know how many justices voted to accept the case. We don't know. And this leads us to outcomes, which I think I'm going to spend most of the next segment talking about. What are the possible outcomes that could come from this case?
The good, the bad, and the ugly.
There are good outcomes, bad outcomes, and ugly outcomes. I think the worst case outcome we can expect is the status quo. And the status quo is really bad. The status quo in the United States is effectively that abortion is a constitutionally protected right. That state governments and the federal government cannot ban abortion prior to fetal viability, and can only ban abortion after fetal viability if there is a health exception, and the health exception, as defined from Doe v. Bolton, which was Roe v. Wade's sister case from 1973, the health exception is so broad that literally every pregnancy triggers the health exception. So you can't really ban any abortion when you have a health exception like that.
And John, also to point out, not only can you not directly ban abortion itself, but you can't even enact common sense health and safety regulations for the clinics themselves.
Right. And you're extremely limited. Again, because of this status the Supreme Court has taken on of being like the nation's top abortion regulatory body. Texas tries to pass a law saying, okay, well, abortion providers need to have admitting privileges within a hospital 30 miles away from each other. That becomes a Supreme Court question. And the Supreme Court said, no, Texas can't do that. So what I'm hoping, we'll get to the hoped for outcomes, but the current situation, I think, is ridiculous and untenable, where essentially anytime a state wants to do anything to regulate abortion, it becomes a Supreme Court question. At the very least, I hope whatever the court does in the Dobbs case, they get out of this role of constantly tinkering and second-guessing everything a state does. All right, when we return, we'll talk about hopefully some of the good outcomes and the likelihood of how the court could break down ideologically. This is Right to Life Radio on Power Talk. John Gerardi and Jonathan Keller for Right to Life of Central California. This is Daft Punk with Give Life Back to Music here on Right to Life Radio. Very familiar music for those of you who listen to The John Gerardi Show, because this is the opening bumper music for The John Gerardi Show every week, or every day, rather, from 6 to 7 p.m. every Monday through Friday right here on Power Talk. So
it's just some good good music.
There you go.
I just,
Well,
say what you will about modern pop and everything, but Daft Punk that's some quality stuff.
Some pretty cool robots. All
That's right.
Right to Life Radio. Thank you all so much for listening. Jonathan Keller here with me. All right, Jonathan. We're discussing the upcoming Supreme Court case on abortion, Dobbs v. Jackson Women's Health Organization. The Supreme Court just recently announced they were going to take that case. And we're going through in our heads some of the possible outcomes. This case is basically going to be the case that has the potential to overturn Roe v. Wade. Mississippi passed a law basically banning abortions from 15 weeks of pregnancy onward. The Roe v. Wade successor case, Planned Parenthood versus Casey, basically says states and the federal government cannot ban abortion prior to fetal viability. 15 weeks is long before fetal viability. So the Supreme Court might be considering changing its prior rules to allow states and the federal government to ban abortion before fetal viability, either to let them do whatever they want or to draw some new stupid artificial line. So those, I think, are the options. So let's go through the alternatives of what could happen. The worst case scenario is they just leave everything the way it is. And that's terrible because the way it is, not only is it terrible because no state or federal government is really able to ban abortion as such for any period of pregnancy, giving the United States some of the most permissive abortion laws in the world. Not only that, but also it makes the Supreme Court into basically the nation's largest abortion regulatory board, where basically every single case, every single time that a state tries to pass some kind of abortion regulation that hasn't been thought of before, it turns into a Supreme Court case, which is not the way it works for any other kind of healthcare procedure at all. So that would be the worst case scenario. But the best case scenario that we can hope for is that the Supreme Court says we are out of the business of regulating abortion. States just regulate abortion however the heck you want. The Constitution doesn't say anything about abortion. Ergo, do whatever you want. Now, I'm not saying I shouldn't.
Kind of like Pontius Pilate, just wash their hands of the whole situation.
Well, kind of. So I should clarify by saying it's not the best case scenario. The best case scenario would be for the Supreme Court to say, hey, all this stuff in the Constitution about life, liberty, and human dignity. Maybe there's something in the Constitution that protects some sort of notion of human dignity that maybe should apply to all human beings. And maybe
perhaps the 14th Amendment saying that no person should be deprived
of life, liberty, or property without due process of law.
Call me crazy, but
maybe we have learned as a country the problems of excluding certain segments of the human family from the protection of the law, and that maybe we should just stop doing that with our Constitution. That would be the best case scenario. I don't know that there are 5 votes on the Supreme Court to do that, unfortunately. So the second best outcome we can hope for is, at the very least, just let every state regulate, and the federal government also, because that's an important thing. Let every state and the federal government regulate abortion the way they want. And if that were to happen, we can be sure that a bunch of states would ban abortion pretty much overnight. Texas just passed a law banning abortion after the 6-week point of pregnancy. A bunch of other states have done similarly. Ohio did. Louisiana
and
did.
by just, we mean like within the last 2 weeks.
Yeah, Texas just did that very recently. And a bunch of other states have done similarly. And all of those laws have been enjoined from going into effect, basically prevented by the courts from coming into effect because they contradict Planned Parenthood versus Casey, which is the existing Supreme Court precedent. Now, I think we'll save this sort of longer discussion for after the break. But how do we realistically think it's going to happen? And this will be me and Jonathan engaging in pure BS, just pure spitting into the wind.
Yep.
Spitballing how we think these Supreme Court justices are going to rule. We know how some of them are going to rule, at the very least, because they already have stuff on the books, or you can, it's not too hard to figure out. But you don't know. And the outcome of this case, I think more than anything else, defines really the Trump legacy. I don't think it's a stretch to say that the most significant and enduring thing that Donald Trump did was appoint 3 Supreme Court justices. And this will be their most significant and enduring case. So when we return, how do we think the justices on the court are going to rule? How is Justice Barrett, Justice Gorsuch, Justice Kavanaugh, and the always unpredictable Justice Roberts. How will they rule on a case to overturn Roe v. Wade? Next on Right to Life Radio, John Gerardi and Jonathan Keller. Right to Life Radio. John Gerardi. Jonathan Keller.
This is Coast to Coast with George Norris.
Or is it Art Bell now?
I think it was Art Bell. Or I don't know who it was, but it's that late night.
Which is on Power Talk, one of our shows here on Power Talk.
And hey, to their credit,
I think they called this UFO thing.
Gotta say.
Jeez Louise. I mean, they had a big 60 Minutes story about a bunch of naval fighter pilots talking about it seeing UFOs. Anyway, this song is actually called The Chase by Giorgio Moroder. And as many of you know, it seems like we're just doing all of the opening bumper music from different Power Talk shows.
Hey.
We had Giorgio Moroder, The Chase for Coast to Coast. We had the John Gerardi opening theme. All we need now is just doom, doom. Anyway,
and I don't even know what the name of that song is.
It is an actual.
It's a song.
It is an actual
song.
real popular song that just Rush liked and made it 20 times more popular than it ever would have been. Anyway, Right to Life Radio, John Girardi, Jonathan Keller. Thank you all so much for listening. All right, Jonathan, we're going to engage in reckless, wild speculation in this segment of the show. We're going to talk about how we think the Supreme Court justices are going to rule in Dobbs v. Jackson Women's Health Organization. This is the big Supreme Court case, the big challenge to Roe v. Wade and Planned Parenthood versus Casey, where the court is being asked the question, can states or the federal government regulate abortion before fetal viability? That is the big question. If the court says yes, just simply yes, then it means that states can regulate abortion however they want, and abortion will probably be effectively outlawed in many, many states of the union. If the court says no, then we might be where we are right now, at the status quo, which is terrible.
Let me say this. This is a very cold comfort for, obviously, the millions of babies that are killed every year, and for the pro-life movement, and for all of us that have dutifully supported and made phone calls and made arguments and walked precincts and tried to elect pro-life candidates of every party. I mean,
right.
John, I mean, just so people understand, this whole issue is not just a Republican versus Democrat thing. I mean, our friend Teresa Bukovac is
the new president of Democrats for Life.
I mean, this case is something that pro-lifers from across the ideological spectrum have been waiting for, as you said, like 30 years. Mm-hmm. But it's the one slight consolation. Am I fair in saying that it's hard to imagine? There's a disappointing outcome of this case, but it's hard to imagine a disastrous outcome of this case. Is that fair to say? In the sense that it's hard to imagine it getting worse than the status quo.
It can't get worse, but it could be the same. And we have to remind ourselves, the status quo is terrible.
Yes.
The status quo of what we have in the United States is not just bad, it's objectively far worse than most countries in the Western world. All but 7 countries in the world have better abortion laws than we do.
And that is the thing. If you get a chance, go online and watch the video from our friends at Susan B. Anthony List. If you go on their YouTube page or go to their Twitter account. They had a great new ad that they've just released. It's like I think it's like a 2-minute video. And what did they say? They said, we're launching an initial $2 million campaign highlighting the humanity of unborn children as the Supreme Court prepares to review a landmark abortion case. So I'm sorry. It's a 30-second ad. It's very short.
Yeah.
But it's great. They basically start and they say, look, we have all these incredible scientific advances. We're able to provide care to all these people. And then it flashes back and it shows Walter Cronkite and these 1960, 1970 news anchors. And it says, why we've got this amazing 2020 science, 2021 science. Why are we stuck with 1960s, 1970s abortion laws?
Right, exactly. And the thing to highlight is there are only like 7 countries in the world that allow abortions to take place after 20 weeks of pregnancy.
Yes.
And we are one of them. So even if you go to Europe, I think a lot of people have this assumption that, Europe's so much more liberal than the United States. They must have crazy liberal abortion laws. Actually, not true. Actually, most countries in Europe ban abortion either after the first trimester or at least after the 20-week period of pregnancy. And the United States allows it for all 9 months of pregnancy, along with such respecters of human rights as Vietnam, North Korea, and China. We're in that group. So
hey,
anyway.
all you hip millennials and you hip Gen Z people, you like Sweden and you like Norway, Denmark.
Let's have their abortion laws rather than ours. Anyway, so it's not going to get worse, but the status quo is terrible, and the status quo is a possibility. So I think to break this down, let's look at the individual members of the court, and I'll go sometimes by groups and sometimes by individuals. So walk with me through this, Jonathan.
All right.
Let's start with the liberal wing of the court. Breyer, Sotomayor, and Kagan. Safe to say that they, at the very least, want the current status quo to continue. I think if they had it their way, they would even have a worse legal regime than what we currently have. I think Planned Parenthood versus Casey was not a great decision. I think in a number of respects, even Justice Ginsburg criticized it. She thought that abortion rights should be grounded differently than how Justice Kennedy did. I think it's worth noting that 2 of the loosest, goosiest legal thinkers on the Supreme Court, Anthony Kennedy and Sandra Day O'Connor, were 2 of the 3 people who, adopted the plurality. That was the other thing about Planned Parenthood versus Casey from 1992. It was the controlling opinion, but it was just a plurality opinion, meaning you didn't even have a majority of the court really supporting it. They sort of agreed with the outcome. So anyway, it was a strange situation. So the liberal justices on the court, at the very least, want the status quo to continue. They want probably more than that. They probably want to eliminate the limited ways in which Planned Parenthood versus Casey and Roe v. as the successor to Roe v. Wade. They want to limit the ways in which Planned Parenthood versus Casey, the 1992 successor to Roe v. Wade, limit the ways in which state governments can sort of regulate abortion around the peripheries. So that's the liberal justices. We almost don't even need to consider them. Let's go to the far right wing of the court. Let's go to Clarence Thomas and Sam Alito. I have no concerns about those 2. I think I know exactly where they stand. I think they are going to say state governments should be able to regulate abortion however they want. Justice Thomas was one of the dissenters from Planned Parenthood versus Casey. He's the only justice who was on the court during Casey, so his opinion is well known. He has expressed his opinion in several abortion cases since, and is very reliable. Justice Alito has similarly never ruled the wrong way on an abortion case ever, and I have no worries about how he's going to rule on this stuff. Now let's talk about some of the people in the middle. Justice Barrett. I am not concerned about Justice Barrett. I think there is maybe a sense...
Folks, mark it down.
Mark it down.
Saturday, the 29th of May.
John Gerardi is not concerned about Justice Barrett.
I sincerely hope you are right.
Right.
And I don't have any reason to doubt you, but I just have...
You sound like you have some slight reason.
Not of Justice Barrett. I just John, we've just been burned so many times.
I know.
But of all the people,
I cannot fathom that Justice Barrett would do the wrong thing in this case.
You
just knowing her and her background and the kind of person she is, and I just cannot fathom that she would do the wrong thing here.
You started by listing her in the middle. So do you really think she's in the middle, or do you think at least on this issue?
I think so, only in this regard. She is very new on the court. This is going to be her first really significant case.
And
I think during the...
She's the first pro-life woman to ever be on the court.
Right. And I do think you saw during some of the election cases that there was a desire on the court not to have her be super in the middle of highly contested political stuff, but that she was sort of... There was like even one decision that the court issued where only 8 justices ruled, where she didn't participate in the proceedings when she possibly could have. So I think there's maybe a little bit more of a PR sense with her of like, she just joined the court. Is she really going to do this really horrible thing? That's my only barely slightest concern with her. But I think there are like 20 million reasons otherwise to think that she will just rule the right way. So she's not the least of my concerns, but very, very low on the list of my concerns. Next, we come to Neil Gorsuch. Neil Gorsuch, he deserves to have scrutiny from conservatives for the rest of his time on the court because of the Bostock decision. And that was a horrible decision on his part. Well, Rights to Life Central California does not take a position on that.
I will. CFC will say that was a horrible decision.
Yeah, and John Gerardi personally will say, I think that was a terrible decision. And it makes me really question how he thinks originalism even works. Makes me question originalism itself, frankly.
It's kind of like... For all those people that are like, what parade of horribles? Justice Gorsuch is like, allow me to strike up the band for this parade of horribles.
So the Bostock decision, for those who don't know, basically Justice Gorsuch reinterpreted federal law, which bans discrimination on the basis of sex, which had always just been viewed as banning discrimination in employment on the basis of sex, meaning if you're a girl, you can't discriminate against someone for being a girl. If you're a boy, you can't discriminate against someone for being a boy in hiring. Reinterpreted that the word sex, biological sex, to refer to sexual orientation and gender identity. So, which Congress had tried to pass laws including that as something that's unlawful discrimination. And Justice Gorsuch sort of said, just reread the Constitution to say something that it clearly did not mean, that the people who wrote the Civil Rights Act in the 1960s clearly were not trying to defend gender identity, a concept that no one in the 1960s even understood. Certainly not the members of Congress who drafted the Civil Rights Act. So anyway, Justice Gorsuch deserves scrutiny from conservatives from the Bostock decision onward, no doubt. However, outside of that one decision, which is a big exception, Justice Gorsuch has been actually really hardline conservative on every single other issue. And having read his book on... I feel like George C. Scott and Patton talking about Rommel. Rommel, I read your book! Having read his book on physician-assisted suicide... Sorry, kind of blew out the microphones there. Having read his book on physician-assisted suicide, which is a great book and a phenomenal treatment of physician-assisted suicide, actually, I have pretty good confidence that Justice Gorsuch is going to rule the right way. Now we come... and we'll probably discuss them for the end of this segment and the start of the next. The two great wild cards, John Roberts and Brett Kavanaugh. I want to start with John Roberts, while Jonathan, for some reason, whistles the theme to The Good, the Bad, and the Ugly. For John Roberts, this is the ugly part of The Good, the Bad, and the Ugly.
That's right.
Or maybe just the bad part. John Roberts is a mystery wrapped in an enigma, wrapped in a riddle. He is, I think, the most conflicted person on the Supreme Court, the most self-absorbed member of the court in a long time. I think he is terrified by Democrat threats to pack the Supreme Court, which, in spite of the fact that Democrats have at least a technical majority in the Senate and the House, they certainly don't have the horses to pack the Supreme Court. And a number of Democrats, senators from purple states, have committed that they're not going to pack the court. They're not going to pack the court. They're not going to pack the court. But Roberts is terrified of the notion. He's terrified of the court being viewed as a political institution, a politicized institution, and I think it's because he breathes this air of elite Washington legal academia and legal practice. He gets invited to Harvard Law School, he gets invited to Yale Law School. This is the air that he breathes. And the concerns from that crowd is, it's a conservative court appointed by conservative presidents, just going to be a blunt instrument for empowering conservative policy. And Roberts, I think, is bending over backwards to try to demonstrate, no, I'm neutral. No, I'm unbiased. No, we're just doing law. We're not doing anything related to policy or policy preferences at all. There's nothing political about this. Which has led him to tie himself into so many pretzels that he found himself ruling against his own ruling. He in the 2020... He ruled in a 2020 abortion case against the same position he adopted in a 2016 abortion case.
It's funny, John, how it seems like the social conservative issues are always the ones that get short shrift when we're trying to split the baby, no pun intended.
Well, again, he's a rich lawyer talking with a bunch of other rich lawyers who don't really care about, they don't care about conservative policies about tax or regulatory oversight or things like that. What they care about is abortion. What they care about is gay marriage. What they care about are these discrimination on the basis of LGBT. So with Justice Roberts, who, let's not forget, Justice Roberts also ruled the wrong way in Bostock and has ruled the wrong way in now one abortion decision. John Roberts, I think, I'm not sure how he's going to rule. But there is an issue relating to Justice Thomas that makes me think he might rule the right way. We'll discuss that and Brett Kavanaugh after the break. This is Right to Life Radio right here on Power Talk, a production of Right to Life of Central California, rtlcc.org. Right to Life Radio with John Gerardi and Jonathan Keller.
Almost feels weird to be using this.
It kind of does feel weird. I'm almost regretting the decision.
But it's an homage.
It's an homage to Rush Limbaugh.
Rest in peace.
We've been doing today opening bumper music for all of the different shows on Power Talk. It was my show, then the John Gerardi Show, Monday through Friday, 6 to 7 p.m., then Coast to Coast, their opening bumper song, The Chase by Giorgio Moroder, and now My City Was Gone by The Pretenders, a song that would not be very famous at all had it not been for the fact that Rush Limbaugh decided a billion years ago to make it his bumper music. So anyway, rest in peace, Rush. All right, Right to Life Radio, as always, brought to you by Right to Life of Central California. And we want to thank our 300 Club members. These are those of you who are contributing $25 a month, that's $300 a year, to support Right to Life of Central California. It helps us carry on our day-to-day operations, and it's a wonderful way if you're not a multi-bazillionaire, if you're not a rich, fancy lawyer like John Roberts, you can still contribute. So I want to thank all the people who've signed up in May. Marianne Belfi, Mike and Leanne Bone, Barbara Fletcher, M. Jean Floro, Vicente and Maria Rios Garza, Nathan Ribb, John Thornton, Luis and Cecilia Vasquez, and also renewing his 300 Club subscription, one John and Holly Gerardi.
Aww.
So there you go. Thank you all of you, and thank you to myself for supporting the 300 Club.
This has a very Snoop Dogg feel to it. I would like to thank me.
I would like to thank Snoop Dogg. Yeah. Anyway, thank you all. In all seriousness, thank you to all of you who have supported Right to Life Central California through the 300 Club. Okay, so Jonathan, we're not sure how John Roberts is going to rule on this case before the Supreme Court. Dobbs v. Jackson Women's Health Organization. This could be the most important Supreme Court case on abortion ever. This could be the case that overturns Roe v. Wade, that basically says states can regulate abortion however you want. I am pretty confident that the three Democrat appointees on the court will rule the wrong way. I am pretty confident, at least, that Justice Barrett, Justice Gorsuch, Justice Thomas, and Justice Alito will rule the correct way. And I'm a little concerned about the two guys in the middle, John Roberts and Brett Kavanaugh. Now, Brett Kavanaugh, I think, will rule the right way because of this. Brett Kavanaugh gave a speech in 2017 about a famous Supreme Court decision called Glucksberg v. Washington. Glucksberg v. Washington could have been the Roe v. Wade of physician-assisted suicide, and it was not. Justice Rehnquist sort of led the way and basically said, no, we're not going to create new rights out of the 14th Amendment due process clause. We're not, which is what happened in Roe. The 14th Amendment says that no state shall deprive any person of life, liberty, or property without due process of law. Somehow, the court in Roe v. Wade and Planned Parenthood versus Casey found a right to abortion hidden in there, which is really was a procedural guarantee of fair trials that the federal government was imposing on state governments after the Civil War. Hey, you southern states who just fought us in the Civil War don't have unfair legal processes for black people and fair legal processes for white people. Basically, what Justice Rehnquist was saying was, hey, let's put a pause on this whole mania the Supreme Court has for creating new rights out of the 14th Amendment due process clause by saying you can't create any new substantive rights out of the 14th Amendment due process clause unless those rights are essential to a scheme of ordered liberty and are deeply rooted in American history and tradition. Rehnquist applied that standard in this case called Washington v. Glucksberg. That's where he came up with the standard, and using that standard said, no, there's no right in the Constitution to physician-assisted suicide because that has no grounding in American history or tradition. Brett Kavanaugh, citing that, said that if that in a speech in 2017 when he was a circuit court judge before he was on the Supreme Court, said if the court had applied that standard in Roe and Casey would have been decided differently. And he was glowing talking about Glucksberg, saying that this is such a good case. He has a lot of affection for Rehnquist. So I think Kavanaugh could rule the right way. I think applying that standard, Kavanaugh is going to come to the conclusion that no, abortion is not a right that's rooted in the history and tradition of the Constitution and should not be said to originate from the 14th Amendment. My only concern is Kavanaugh willing to upset the apple cart?
And can he pull Roberts along with him? I know he doesn't need to.
Right.
But, John, am I correct in saying that
in the last 30 seconds,
the absolute last thing that John Roberts wants, like his greatest fear, is for this to be a 5-4 decision that chips away at Roe?
I would say so. And here's the thing. He also, I think, if he knows it's 5-4 to overturn Roe, he will probably want to have a hand in deciding it. If you're the Chief Justice in the majority, you get to decide who writes the case. So I think it's much more likely to have a 6-3 overturn of Roe than a 5-4. So we will see. I am hopeful that Brett Kavanaugh will do the right thing, and that gives me hope that the case will be decided correctly. Well, we'll be following all this next year once the decision is released next year. Thank you for listening to Right to Life Radio. We'll see you next week.